I don't know which of the three branches of government does the most to infringe on your rights. Take, for example, the recent Supreme Court decision in the case Bondi versus Vanderstok, where Mr. Vanderstok challenged the recent regulations from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, redefining weapons parts kits as firearms. It seems the Supreme Court has a hard time reading either the law or the Constitution. So we'll discuss that next, right here in the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach rising generation be free. This case, now known as Bondi versus Vanderstok, has been of great interest among the firearms community in this country because it really is a question of, well, they're called ghost guns, but it's really home-built firearms. And does the ATF have the authority to simply redefine that in violation of the law? That's the primary question here, and that's the one that we'll get to. Now, if you want to find my sources, where I got my information, well, go to the website constitutionstudy.com. You'll find the written article where every quote has a link to the source material, so you can double-check my work. I love when people double-check my work. Now, I'll talk more about the website and some other things at the end of the episode, but for now, let's get into this case, Bondi versus Vanderstok. While this lawsuit questions the actions of the ATF, the events actually start all the way back in 1968. The Gun Control Act of 1968, called GCA, requires those engaged in importing, manufacturing, or dealing in firearms to obtain federal licenses, keep sales records, and conduct background checks, and mark their products with serial numbers. Well, the case was filed in 2023. It really begins with the Gun Control Act of 1968. However, what Justice Gorsuch stated in the opinion about what the law says is not exactly correct. The Gun Control Act reads, "It shall be unlawful for any person except a licensed importer, licensed manufacturer, or licensed dealer to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce, or except a licensed importer or licensed manufacturer to engage in the business of importing or manufacturing ammunition, or in the course of such business to ship, transport, or receive any ammunition in interstate or foreign commerce." You see, the Gun Control Act only prohibits a person from participating in certain forms of interstate commerce. As defined in the GCA, the term interstate or foreign commerce includes commerce between any place in a state and any place outside of that state, or within a possession of the United States, not including the Canal Zone, or the District of Columbia, but such terms does not include commerce between places within the same state, but through any place outside of that state. The term state includes the District of Columbia, the Commonwealth of Puerto Rico, and the possessions of the United States, not including the Canal Zone. Now, this is allowed because Congress has the authority under the Constitution to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Act also defines a firearm as the term firearm means any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, or any firearm muffler or firearm silencer, or any destructive device. Such terms do not include an antique firearm. Now, why did Congress pass this legislation? Shortly after the assassination of Senator Robert F. Kennedy and Dr. Martin Luther King Jr. stunned the nation, Congress adopted the Gun Control Act of 1968, the GCA. Existing gun control measures, Congress found, allowed criminals to acquire legally untraceable guns too easily. Once again, Congress exceeds its constitutional authority because it saw a need and thought it knew better than the Founding Fathers. In response, Congress adopted a number of new mandates. As a result, many of those now engaged in importing, manufacturing, or dealing in firearms must obtain federal licenses, keep records of their sales, and conduct background checks before transferring firearms to private buyers. And the Act also requires importers and manufacturers to mark their firearms with serial numbers. Again, the Supreme Court reads into the law language that does not exist, because that language of the law only impacts any firearm in interstate or foreign commerce. These mandates serve at least two ends. The background check requirement seeks to keep guns out of the hands of criminals. The problem is, just because Congress thinks keeping a gun out of the hands of criminals is a good thing, which I tend to agree with, that doesn't mean they can break the law to do so. In the midst of this, the ATF promulgated a new regulation. In 2022, the Bureau of Alcohol, Tobacco, and Firearms and Explosives adopted a rule interpreting the act to cover weapons parts kits that are designed or may readily be converted to expel a projectile, and partially complete, disassembled, or non-functional frames or receivers. This is the core of the issue in this case. Do executive agencies have the legal authority to effectively rewrite federal law? As the court points out, the GCA's mandate applied to firearms, and the law defines the key term broadly. Thanks to this generous definition, the GCA has long been understood to reach everything from the run-of-the-mill rifles to novelty umbrella guns. The GCA may have been understood to reach a lot of different weapons, but only when they are in interstate or foreign commerce. The fact that so many people keep forgetting this has led to more and more infringements. Recent years, however, have witnessed profound changes in how guns are made and sold. When Congress adopted the GCA in 1968, the milling equipment, materials needed, and designs were far too expensive for individuals to make firearms practically or reliably on their own. With the introduction of new technologies like 3D printing and reinforced polymers, that is no longer true. Today, companies are able to make and sell weapons parts kits that individuals can assemble into functional firearms in their own homes. Yes, things change over time. But who is responsible for making sure the laws keep up with the times? The agencies or Congress? Because it certainly is not the courts. Once again, the Supreme Court wants to justify rewriting the rules. Some manufacturers and dealers take the position that weapon parts kits do not qualify as firearms subject to the GCA. As a result, they say they are free to sell their products without obtaining a federal license, conducting background checks, maintaining sales records, or barking components with serial numbers. To be fair, that is what the law says. The term firearm means any weapon, including a starter pistol, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, or any destructive device. The law says nothing about firearm components. The law also says that the prohibitions are against firearms in interstate or foreign commerce. This is where the ATF decided to step in and muck things up. Since Congress was unable to pass legislation to include gun part kits, it seems the ATF would step in. In 2022, the Bureau of Alcohol, Tobacco, Firearms, and Explosives adopted a new rule designed to combat the proliferation of ghost guns. So the agency invoked authority Congress granted it to prescribe rules and regulations as necessary to carry out the GCA. Except that's not what 18 U.S.C. Section 926A actually says. It reads, "The Attorney General may prescribe only such rules and regulations as are necessary to carry out the provisions of this chapter." Not only does Section 926 not give the ATF the authority to write rules and regulations, it gives the Attorney General that power. Furthermore, the power is to put into effect the provisions of that chapter of the law, not to rewrite that law. The GCA embraces and thus permits ATF to regulate some weapons parts kits and unfinished frames and receivers, including those we have discussed. Because the Court of Appeals held otherwise, its judgment is reversed, and the case is remanded for further proceedings consistent with this opinion. Except the GCA says no such thing, and the fact that the court thinks it does points to how badly the judiciary has been compromised. At least in this case, not all of the justices are blind. Justice Thomas disagreed with the court. He summarized his dissent in his opening paragraph and again in his closing paragraph. The government asked this court just last term to rewrite statutory text so they could regulate semi-automatic weapons as machine guns. That's Garland versus Cargill. We declined to do so. The government now asks us to rewrite statutory text so that it can regulate weapons parts kits. This time the court obliges. I would not. The statutory terms frame and receiver do not cover the unfinished frames and receivers contained in weapons parts kits, and weapons parts kits themselves do not meet the statutory definition of firearm. That should end the case. The majority instead blesses the government's overreach based on a series of errors regarding both the standard of review and the interpretation of statute. I respectfully dissent. Justice Thomas points out that just last term, the court declined to allow the ATF to rewrite the law. then this term they do. The mere fact that the ATF regulations redefine the word firearm should end the case. Instead, the court blesses the ATF's overreach, and I'm not entirely sure why, as Justice Thomas stated in his closing paragraph. Congress could have authorized ATF to regulate any part of a firearm or any object readily convertible into one, but it did not. Now, I would adhere to the words Congress enacted. Employing its novel artifact noun methodology, the majority charts a different course that invites unforeseeable consequences and offers no limiting principle. I respectfully dissent. As Justice Thomas pointed out, Congress could have authorized the ATF to regulate any part of a firearm, but they did not. By ignoring the law, the Supreme Court has opened up a myriad of unintended consequences, most of which we won't know until it's too late. Justice Alito also wrote a dissent, but for mostly technical reasons. Once again, it appears that justices of the Supreme Court have substituted their opinion for the law. As the court said in the case Marbury versus Madison, it is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. Except in this case, the court didn't expound on the law, but apparently couldn't even be bothered to read the law. For example, the law clearly states its prohibited actions regard any firearm in interstate or foreign commerce. The law grants the Attorney General, not the ATF, the power to write regulations to fulfill the law. And nowhere that I'm aware of does the law grant others the right to define terms in the law. Then there's a point made by Justice Thomas. The court that seemed so concerned with precedent ignored the precedent it had established in Garland versus Cargill in the previous term. A precedent to follow the law as written by Congress, and now decides it's perfectly fine for unelected bureaucrats to rewrite federal law. Not only has the court gotten it wrong when it decided this case, it completely inverted the legal structure of the federal government. According to this court, Congress can overrule the Constitution of the United States, executive regulations supersede U.S. law, and the whims of the court supersede all. Is it any wonder that people don't trust our so-called justice system anymore? This is why I say we don't have a justice system, and this court just helped prove me right. Now, I'm sure some of you will be saying, but Paul, you didn't even talk about the Second Amendment. Exactly. This is not a question of the Second Amendment. It's a question of the powers of the executive branch to rewrite federal law. And the court, they mucked it up. They made a mess of it. They screwed up. And I know no other way to put it. But yet we're going to have other courts looking at this court saying, well, sure, executive branches can rewrite the law. You did it in Vanderstok, which basically says they've overruled their previous precedent in Garland versus Cargill. Will this court make up its mind? Even worse, by ignoring the actual text of the law, well, this court has come to a really bad decision. In fact, I might even say behave badly. By looking and saying, well, it's a good idea, we want to let this happen, rather than looking at the language of the law, isn't that bad behavior? Wouldn't that warrant the termination of their terms because of such bad behavior? Now, I don't want to talk about impeaching a judge simply because they got a decision wrong, but I'm worried about the fundamentals of how they got there. Just last term, they said agencies cannot rewrite law, and now they say they can. Would they please make up their mind? Better yet, would the real Supreme Court justices please stand up? Because you're not following your oath of office, and that disturbs me greatly. Now, if you want to learn more about the limitations on, well, not just the courts, but the entire federal government, might I recommend my book, The Constitution Study, Returning the Constitution to We the People. It's a clause-by-clause study of the Declaration of Independence and the Constitution, each and every clause written in plain conversational English that everyone can understand. Find it at constitutionstudy.com/shop or Amazon or other places where books are sold. John Jay said that every member of the state ought diligently to read and study the Constitution of his country. Well, here's an opportunity for you to do just that. There's another course I found that's really cool. It's called The Miracle of America. You wonder what makes America great? Well, it's a miracle that we're here. This course covers our history basically from the Pilgrims through the drafting of the Constitution. It helps explain why the Declaration and Constitution are written the way they are. Now, I made a deal with the owners. Go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You'll be taken to a custom landing page where you can not only read up about the course, you can enroll for a lesson on God's natural law absolutely free. Again, go to constitutionstudy.com/1776 study guide to read up about the course and to get your free lesson on God's natural law. You can also support the work that we're doing here with your cell phone. Join Patriot Mobile, America's only Christian conservative wireless provider. I joined them years ago, and I've been very happy with their service. Best of all, they don't spend money with companies and organizations that are trying to destroy our rights, but with organizations that are trying to defend our rights, our freedom of speech, freedom of religion, our right to life, liberty, and the pursuit of happiness. Go to patriotmobile.com/constitution and find a plan that works for you. Maybe you're eligible for a discount. Maybe you're a member of the NRA or a first responder or just a family with multiple lines. And then be sure to use the code Constitution at checkout to get free activation. Once again, that URL is patriotmobile.com/constitution, and the code for free activation is Constitution as well. Whatever you do, I hope you'll come back and join us here and maybe share the links that we have, the link to this video, the podcast, the articles. Share them with friends and family. Share them with neighbors. Share them with community groups. And then invite them all to come back and join us here next time for the Constitution Study.
Love your neighbors and have a few